Welcome to the Deep Dive.
Great to be here.
Today, we're diving into something that, well, really impacts all of us here in South Africa, especially online. It's the Protection of Personal Information Act, POPIA.
Yep, POPIA. It's a big one.
We've got the official government gazette right here, the actual text of the act.
The source itself. Always good to go straight there.
Absolutely. And our mission today is to, cut through some of the dense legal stuff and figure out what POPIA really means for us as individuals and for businesses or any organization handling our data.
Yeah, boiling it down to the essentials, what you need to know.
Exactly. So let's kick off. What actually is personal information, according to POPIA? It seems like a really wide net.
It is, and deliberately so. Basically, POPIA says personal information is any info that relates to an identifiable living person.
Identifiable. So if it can be traced back to me?
Precisely. If it points to you, it's personal info. And the Act lists a whole load of examples, things like race, gender, health status, financial details.
Contact details, too, like email, phone number.
Definitely. Addresses, emails, phone numbers, but also things you might not immediately think of, like your personal opinions, your employment history, even biometric data like fingerprints or, say, facial recognition data.
Wow. Okay. So online identifiers, like an IP address?
That can count too, yeah, if it can be linked back to identify you. It even applies to existing juristic persons, like companies, in certain contexts.
So it's much broader than just name and ID number. It's pretty much anything that paints a picture of who you are.
That's a good way to think about it. If an organization collects it and it's about you, POPIA likely applies.
Okay. And the Act uses the term processing this information. That sounds like more than just collecting it, right?
Oh, much more. Processing is a super broad term in POPIA. It basically covers the entire life cycle of your data within an organization.
The whole life cycle.
Yeah, from the second they collect it, recording it, organizing it, storing it through to using it in any way, maybe updating it, sharing it, linking it with other data, and even right up to destroying or de-identifying it.
So any action taken on the data.
Any operation or activity involving personal information, basically, manual or automated.
Got it. Personal information is the what, processing is the how. Now, who are the main actors in this play? The key roles.
Okay, there are a few key players you need to know. First up, the data subject.
That's us, the people the information is about.
Exactly. You, me, anyone whose data is being processed. Then there's the responsible party.
Responsible party. They're the ones in charge of the data.
Yep. That's the company, the government body, the organization, whoever decides why they need the personal information and how they're going to process it. They're the decision maker.
Like the online store I buy from or my bank?
Perfect examples. They decide to collect your details for delivery or for managing your account. They're the responsible party.
Okay. And then there's the information regulator. Sounds important.
Very important. Think of the regulator as the independent watchdog for data privacy in South Africa.
The watchdog. So they enforce the rules.
That's right. They're established by the Act to monitor compliance, enforce POPIA, handle complaints if you think your rights have been violated, educate the public and organizations, and generally make sure the whole system works to protect personal info.
So if I have a problem, I can go to them.
Absolutely. They're the main recourse for data subjects. They have investigation powers. They can issue notices, even fines.
Good to know. And the last one mentioned is the information officer. Who's that within an organization?
Right. So every responsible party, every company or public body processing personal info has to designate an information officer. Usually it's the CEO or head of the body by default, but they can delegate it.
And what do they do?
Their job is to ensure the organization actually complies with POPIA. They encourage compliance, handle data subject requests like accessing information, work with the regulator, and sort of champion data protection internally.
The internal POPIA person.
Pretty much. And they often have deputy information officers to help out, especially in larger organizations.
Okay, that clarifies the main players. The Act also defines a few other terms quickly. Biometrics, child, consent. What's the quick take on those?
Sure. Biometrics is biological data used to identify someone, fingerprints, facial patterns, voice recognition, that kind of thing.
Right, and child.
Under POPIA, a child is a natural person under the age of 18 who isn't legally competent to make their own decisions yet. So processing their info has stricter rules.
Makes sense. And consent, this seems key.
Hugely key. Consent has to be a voluntary, specific, and informed expression of will. You have to clearly agree to your data being processed for a particular reason. It can't be vague or forced.
So no pre-tick boxes hidden somewhere.
Ideally, no. It should be an active agreement.
Okay. What about de-identify? We hear that a lot.
De-identify means removing or altering information so that it can no longer be linked back to a specific individual. Properly de-identified data falls outside most of POPIA's rules because it's no longer personal.
Anonymized, essentially.
Exactly. But it has to be done properly so you can't re-identify the person easily.
And just quickly, direct marketing, special personal information, and unique identifier.
Okay. Direct marketing is contacting you directly email, SMS, phone, to promote something. POPIA has specific rules for that, especially unsolicited messages.
Right, the spam rules.
Kinda, yeah.
Right.
Special personal information is a category that gets extra protection because it's sensitive. Think race, ethnic origin, trade union membership, health, sex life, religion, political beliefs, criminal behavior, and biometrics.
So higher risk data needs higher protection.
Precisely. And a unique identifier is just any identifier assigned by a responsible party, like a customer number, employee number, anything like that that uniquely identifies you within their system.
Okay, I think we've got the basic language down. Now let's dig into the real heart, the core principles, the conditions for lawful processing in Chapter 3. First up is accountability.
Right, accountability, Section 8. This basically puts the onus squarely on the responsible party. They're responsible for ensuring that all the conditions for lawful processing we're about to talk about are actually met.
So the buck stops with them.
Entirely. They have
Right.
to demonstrate compliance. They can't just say they comply. They need to, implement measures and be able to show it.
Okay. Next principle, processing limitation. This seems to have a few parts. Let's start with lawfulness and reasonableness.
Yeah, sections 9 to 12 cover processing limitation. Lawfulness means the processing must, comply with the law, POPIA itself, and any other relevant laws. And reasonableness means it has to be done in a way that doesn't unreasonably infringe on the data subject's privacy.
Fair and legal.
Basically, yes.
Mm-hmm.
And it shouldn't be excessive, which leads to the next part, minimality.
Minimality. So collect only what you absolutely need.
Exactly that. You should only process personal information that is adequate, relevant, and not excessive for the purpose you collected it for. No collecting extra data just in case it might be useful later.
Stick to the purpose.
Stick to the purpose and only take what's needed for that purpose.
Okay. Then, under processing limitation, we have consent, justification, and objection. This feels really central for individuals.
It absolutely is. The default starting point is usually consent. The responsible party needs your voluntary, specific, informed consent.
But you mentioned justification, so there are times they don't need my consent.
Correct. POPIA outlines specific justifications where consent isn't required. For example, if processing is necessary to carry out a contract you're part of.
Like giving my address for a delivery I ordered.
Perfect example. Or if processing is required by law, or to protect your vital interests, like in a medical emergency, or if it's necessary for the responsible party's legitimate interests, or the legitimate interests of a third party they're disclosing to.
Legitimate interests sounds a bit vague. What does that cover?
It can be things like preventing fraud, ensuring network security, or direct marketing in some limited cases, but it must be balanced against your right to privacy, not a free pass. And importantly, you generally have the right to object to processing based on legitimate interests.
I can object, even if they have a legitimate interest.
Yes, on reasonable grounds relating to your particular situation. And you have an absolute right to object to processing for direct marketing purposes. If you object, they have to stop. You can also withdraw your consent at any time if consent was the basis for processing.
Okay, so consent is preferred, but there are justifications, and we still have the right to object in many cases. What about the last part? Collection directly from data subject.
The principle here is transparency. Ideally, organizations should collect your personal information directly from you. That way you know what's happening.
But that's not always possible, is it?
No. So there are exceptions. For example, if the information is already publicly available, or if getting it directly from you would prejudice a lawful purpose, like a fraud investigation, or if it's just not reasonably practicable in the circumstances. But the default should be direct collection.
Right. Get it from the source unless there's a good reason not to. Okay, moving on to the next core principle. Purpose specification.
Sections 13 and 14. This ties into minimality. First part, collection for a specific purpose. Organizations must collect personal information for a specific, explicitly defined and lawful purpose related to their function or activity.
They need to know why they're collecting it beforehand.
And they need to be clear about that purpose. They can't just collect it vaguely.
And the second part, retention and restriction of records. How long can they keep my data?
not longer than necessary to achieve the purpose for which it was collected. That's the rule. Unless retention is required or authorized by law, or they reasonably need it for lawful purposes related to their functions, or it's required by a contract, or, you guessed it, the data subject consents to longer retention.
So once the purpose is done, they should delete or de-identify it.
Exactly. Securely destroy or de-identify it so it's no longer personal information. And this section also introduces your right to request the restriction of processing in certain cases.
Restriction, like pause the processing.
Sort of. You can ask them to restrict processing if you're contesting the accuracy of the data, or if the processing is unlawful, but you want them to hold on to it perhaps for legal reasons, or if they no longer need it for the original purpose, but you need it for a legal claim.
Okay, another layer of control for us. What about further processing limitation, Section 15?
This addresses using data for a new purpose, different from the one it was originally collected for.
Can they do that?
Generally, only if the new purpose is compatible with the original purpose.
Compatible. How do you judge that?
The Act gives factors to consider, like the relationship between the purposes, the nature of the information, the consequences for the data subject, how the information was collected, and any safeguards. If it's not compatible, they typically need your consent for the new purpose.
So no big surprises down the line about how my data is being used.
That's the idea, unless, again, it's allowed by law or the information came from public records, for instance.
Okay. Next, information quality, Section 16.
This sounds straightforward. It is. Mostly. Responsible parties need to take reasonably practicable steps to ensure the personal information they process is complete, accurate, not misleading, and updated where necessary for the purpose.
Keep it correct.
Keep it correct and relevant for the purpose they're using it for.
Right. Then we hit openness, Sections 17 and 18. This includes documentation and notification to data subject. Let's focus on notification. What do they have to tell us when they collect our info?
This is really crucial for transparency. Section 18 says when collecting personal information, the responsible party must take reasonable steps to make the data subject aware of several things.
Such as?
The information being collected, and if it's not collected from you directly, the source, the name and address of the responsible party, the purpose for collecting it, whether providing the information is voluntary or mandatory.
Okay, keep going.
The consequences if you fail to provide the information, any particular law authorizing or requiring the collection, if they intend to transfer the information to a third country or international organization, and the level of protection there.
Wow, that's a lot. Anything else?
Yes. They also need to inform you about the recipients or categories of recipients of the information, the nature of the information, your right to access and rectify the information, your right to object to processing in certain circumstances, and crucially, your right to lodge a complaint with the information regulator, including their contact details.
That's quite a comprehensive list, so we should be getting these privacy notices quite often.
You should, whenever your data is collected, unless an exception applies.
What are the exceptions? When do they not have to tell us all this?
Exceptions include if you've already consented to non-notification, if it wouldn't prejudice legitimate interests, like law enforcement again, if compliance isn't reasonably practicable, or if the information won't be used in a form that identifies you, like for anonymized statistics.
Okay, but the general rule is be open and tell the data subject what's going on.
Absolutely. Openness is key.
Next, security safeguards. Sections 19 to 22. Hugely important today.
Definitely. Responsible parties must secure the integrity and confidentiality of personal information in their possession or under their control. They need to take appropriate, reasonable, technical, and organizational measures.
Technical and organizational, like what?
Technical measures could be things like encryption, firewalls, access controls, software security. Organizational measures are more about policies, procedures, staff training, physical security, limiting who has access. It's about protecting against loss, damage, and unauthorized access or destruction.
Makes sense. And they need to identify risks and keep safeguards updated.
Yes, it's an ongoing process. Identify risks, establish safeguards, verify they're effective, and update them as needed. And this duty extends to operators, third parties processing data on their behalf. They also need security measures and must notify the responsible party of any breaches.
And what happens if there is a breach? A data leak?
If there are reasonable grounds to believe personal information has been accessed or acquired by an unauthorized person, the responsible party must notify the information regulator and also the data subject as soon as reasonably possible.
They have to tell us if our data might have been compromised.
Yes, unless identity can't be established or law enforcement requires a delay. The notification needs to give you enough information to take protective measures, like changing passwords.
Okay, that's a critical requirement. Finally, for the core principles, data subject participation, sections 23 to 25. This is about our rights to interact with our data.
Exactly. First, access to personal information, Section 23. You have the right to ask a responsible party, free of charge, whether or not they hold personal information about you.
Just to confirm if they have anything.
Yes. And if they do, you have the right to request a record or a description of that personal information. They might charge a fee for providing the actual record, but they have to tell you first.
And can I find out who else they've shared it with?
Yes. You can also request the identity of all third parties or categories of third parties who have had access to your information. They have to provide this within a reasonable time and in a reasonable manner and format.
And they have to tell me I can ask for corrections.
Correct. They must advise you of your right to request correction under Section 24.
Okay, so Section 24 is correction of personal information. What can I ask them to correct?
You can request them to correct or delete personal information that is inaccurate, irrelevant, excessive, out of date, incomplete, misleading, or obtained unlawfully, or even information they're no longer authorized to keep under the retention rules we discussed.
And they have to do it?
They have to take reasonable steps to check the information and correct it, or provide credible evidence supporting why they think it's accurate. If you can't agree, you can insist they attach a note to the record indicating that you requested a correction, but it wasn't made.
So I can at least flag it as disputed.
Yes. And if they do make a correction or deletion that impacts decisions, they should inform relevant third parties where practicable. You have to be notified of the action taken as a result of your request.
Okay, so strong rights to access and correct. Section 25 just mentions the Promotion of Access to Information Act, PACIA, for the how of making requests.
That's right. PIA sets out the procedural mechanics for access requests.
Right. That covers the 8 core principles. Now, POPIA has special rules for special personal information, Part B of Chapter 3. You mentioned this earlier, health, race, politics.
Yes. Section 26 lays down a general prohibition. You cannot process special personal information.
Full stop. Or are there exceptions?
There are specific, limited exceptions detailed in Section 27 onwards. The main one is if the data subject gives explicit consent.
Explicit consent, so a higher bar than normal consent.
Arguably, yes. It needs to be very clear given the sensitivity. Other exceptions include if processing is necessary for legal rights or obligations, for historical or statistical research purposes in the public interest, with safeguards, or if the data subject has deliberately made the information public.
Okay. And then there are specific sections for each type, like religion, race, health.
Exactly. Sections 28 to 33 provide specific authorizations. For example, religious or philosophical groups can process their members' beliefs, but generally can't share it. Race ethnic origin can be processed if needed for identifying people under laws aimed at protection or advancement. Trade unions can process membership info.
What about political persuasion?
Political parties or institutions can process it for their political activities or election participation.
And health or sex life. That seems very sensitive.
Extremely. Processing is allowed for healthcare providers, medical schemes, insurance companies, schools, social services, etc., but under strict conditions, usually involving confidentiality obligations and professional secrecy. There are also rules about genetic data.
And criminal behavior or biometrics?
Generally prohibited unless specific legal grounds exist, like for law enforcement or if obtained lawfully for specific purposes. Biometrics especially have tight controls.
So processing special personal info is the exception, not the rule, and requires strong justification or explicit consent.
That's the essence of it. High risk, high protection.
Then Part C deals with processing of personal information of children, also stricter rules.
Even stricter, yes. Section 34 has a general prohibition on processing a child's personal information. Remember, a child is under 18 and not legally competent.
So generally, you can't process kids' data at all.
Not unless one of the exceptions in Section 35 applies.
And those exceptions are?
The main one is prior consent from a competent person, usually a parent or guardian. Other exceptions mirror those for special personal info, necessary for legal rights obligations, historical statistical research purposes, public interest safeguards, or if the child deliberately made the info public with the competent person's consent.
So parental consent is key.
It's usually the primary route. Also, The regulator can authorize processing in the public interest if it's satisfied there are adequate safeguards for the child.
Makes sense. Extra protection for children is vital. Now, Chapter 4 talks about exemptions. Can organizations sometimes be exempt from POPIA?
In limited circumstances, yes. Section 37 allows the regulator to grant exemptions if the public interest outweighs the privacy interference, or if the processing clearly benefits the data subject or a third party, and that benefit outweighs the interference.
Public interest, like.
The Act mentions things like national security, crime prevention, important economic interests, or maintaining journalistic independence, for example.
Okay. And Section 38 has exemptions for certain public body functions.
Yes, the conditions for lawful processing might not apply if the processing is necessary for specific functions of public bodies related to things like protecting the public from financial loss or dishonesty or regulating professions. It's quite specific.
So exemptions are possible, but narrow and usually related to public functions or overriding public interest.
Correct. They're not a general loophole.
Let's talk about the information regulator again, Chapter 5. We know their role, but how are they set up?
Section 39 establishes the regulator as its own legal entity, independent and subject only to the Constitution and the law. They operate throughout South Africa.
Independence is key. What about their powers, Section 40?
They have broad powers. Education, monitoring compliance, handling complaints, conducting investigations, issuing codes of conduct, facilitating cross-border cooperation, issuing notices, imposing fines, essentially anything needed to protect personal information.
How is the regulator composed? Who runs it?
Sections 41 to 44 deal with this. It's made up of a chairperson and between 2 and 4 other members who can be full-time or part-time. They're appointed by the president based on recommendations from the National Assembly.
So, a parliamentary process. Are there specific qualifications?
Yes, they need relevant knowledge or experience in areas like law, information technology, data management, or human rights. There are rules about terms of office, removal, and importantly, Section 45 deals with conflicts of interest. Members have to disclose potential conflicts.
And they get funding from Parliament.
Yes, primarily funded through parliamentary appropriations, but also potentially through fees collected under the Act, Section 46. They have their own staff, too, Section 47.
And there's an enforcement committee, Section 50.
Yes, the regulator establishes this committee, which includes at least one regulator member and other experts, possibly chaired by a retired judge or experienced lawyer. It investigates and makes recommendations to the regulator on enforcement matters, like issuing fines.
Okay. And Part B of Chapter 5 covers the information officer again. We know they exist, but Section 55 outlines their duties.
Yes, Section 55 lists specific duties like encouraging compliance, dealing with requests, working with the regulator, and ensuring awareness within the organization. Section 56 confirms that bodies must register their information officer with the regulator and can appoint deputy information officers to assist.
So, a clearly defined role with formal responsibilities.
Absolutely.
Chapter 6, prior authorization. We touched on this needing the regulator's permission beforehand for certain things.
Exactly. Section 57 lists the specific processing activities that require prior authorization.
Remind us what those were.
Processing unique identifiers, like ID numbers for a purpose other than the original one, and linking them across different responsible parties. Processing info on criminal behavior or unlawful conduct for third parties. Processing for credit reporting.
Yeah.
And transferring special personal information or children's info to a foreign country without adequate protection laws.
High-risk stuff. And Section 58 says they must notify the regulator and wait.
Yes, they have to notify the regulator, provide details, and suspend processing until the regulator grants authorization or a set period passes. Failing to notify when required is an offense.
Okay. Chapter 7, Codes of Conduct. Section 60, what's the purpose here?
The regulator can issue codes of conduct or approve codes submitted by industry bodies. These codes provide specific guidance on how POPIA applies within a particular sector, body, or activity.
Like a code for doctors or banks.
Precisely. They can clarify rules around lawful processing, information matching, or even automated decision-making within that specific context. They have to be consistent with POPIA, of course.
How are they created? Section 61.
Either the regulator initiates it or a relevant body applies. There's a public consultation process notice in the Gazette, opportunity for submissions before a code is approved.
And once approved, they're published and accessible. Section 62.
Yes. And they must include procedures for handling complaints under the code, Section 63, and be reviewed periodically by the regulator, Section 67.
What happens if an organization subject to a code doesn't follow it? Section 68.
Failing to comply with an approved code is considered a breach of the conditions for lawful processing under POPIA itself, so it can lead to enforcement action.
So codes add another layer of specific rules for certain sectors.
That's right.
Now, Section 69, unsolicited electronic communications, direct marketing. This affects everyone.
Hugely. The general rule is processing personal information for direct marketing using unsolicited electronic communications, email, SMS, automated calls, is prohibited.
Prohibited
Unless one of two things applies.
Yeah.
1, the data subject has given their consent.
Okay, opt-in. What's the other?
2, the data subject is an existing customer whose contact details were obtained in the context of a sale of a product or service.
Right, the existing customer relationship.
Yes, but only if the marketing is for the responsible party's own similar products or services, and the customer was given a reasonable opportunity to object, free of charge, both when their details were collected and in every subsequent communication.
The unsubscribe option.
Exactly. That opt-out must always be present for existing customers. And you can only approach someone once to request their consent if they haven't previously withheld it.
So pretty strict controls on electronic marketing spam.
Yes, definitely leaning towards opt-in or very specific opt-out conditions.
Moving on to Section 71, automated decision-making. This is about AI and algorithms making choices about us.
Yes. It says a data subject has the right not to be subject to a decision which results in legal consequences for them or significantly affects them if that decision is based solely on automated processing intended to profile them.
So I can't be denied a loan purely by an algorithm with no human review.
Generally, no. There are exceptions, though. It's allowed if the decision is taken in the course of entering into or performing a contract, provided measures are in place to safeguard your interests, or if it's authorized by law, or if you've given your consent.
And even if an exception applies.
Even then, the responsible party must inform you that the decision was based on automated processing, and you generally have the right to make representations about it, challenge it, and request human intervention or reconsideration. They also need to provide information about the logic involved.
So some transparency and recourse even when automation is allowed.
Correct. It's about preventing purely automated decisions having major impacts without oversight or appeal.
Chapter 9, Section 72, transborder information flows, sending data overseas.
This is crucial in a globalized world. A responsible party in South Africa cannot transfer personal information to a third party in a foreign country unless certain conditions are met.
What kind of conditions?
The main one is ensuring an adequate level of protection in the recipient country. Either the country's law provides adequate protection, or the recipient is subject to binding corporate rules for multinational groups, or there's a specific agreement in place ensuring adequate protection.
What if the country doesn't have adequate laws?
Then transfer is generally blocked, unless the data subject consents to the transfer, or the transfer is necessary for a contract with the data subject or in their interest, or is for legal claims, or benefits the data subject and getting consent isn't practical, but they'd likely give it.
So protection needs to travel with the data unless there's consent or specific necessity.
That's the principle. Keep South Africans' data safe, even when it leaves the country.
Okay, we've covered the rules. Now, Chapter 10, enforcement. What happens when things go wrong? Section 73 defines interference with protection.
Right. And interference is basically any breach of the conditions for a lawful processing or non-compliance with specific obligations, like security breach notification, direct marketing rules, automated decision rules, transborder flow rules, or failing to comply with an enforcement notice or a code of conduct.
So any violation is an interference. And then what? Complaints. Section 74, Tat 81.
Yes, any person can submit a complaint to the information regulator if they believe there's been an interference with the protection of their personal information.
What does the regulator do with a complaint?
They can conduct a pre-investigation, try to mediate or conciliate between the parties, decide to take no action, for example, if a complaint is frivolous or delayed, conduct a full investigation, refer it to the enforcement committee, or take other steps like issuing an enforcement notice. They have to keep the complainant and the responsible party informed. The regulator can also initiate investigations on its own.
So they investigate and try to resolve it. What about search warrants, sections 82 to 84?
If needed for an investigation, the regulator can apply to a judge or magistrate for a warrant to enter and search premises, inspect records, and seize evidence under specific conditions.
Serious investigation powers, and if they find an interference, enforcement notices, sections 89-96.
If the regulator is satisfied an interference has occurred, They can serve an enforcement notice on the responsible party. This notice details the breach and requires them to take specific steps or stop specific actions within a certain time frame to remedy it.
Like ordering them to stop processing data unlawfully.
Exactly. Or ordering them to implement better security or delete data they shouldn't have. These notices